Welcome friends, we have started this channel called Corporate Laws Galaxy. You know, galaxy means group of stars and every star represents different laws. And we are starting with a series on frequently asked questions on very interesting topics of corporate laws. And we are inviting you, all of you, to also send your queries in our comments column in our video, and we will certainly take up those queries also in our videos. And now I will request you to please share, like and subscribe to our channel. Thank you so much.
Namaskar. Sir, I have come across a frequently asked question from our professional colleague regarding Doctrine of Res Judicata. Sir, could you please explain whether this doctrine is applicable to proceedings under IBC 2016?
Intelligent and technical question. You see, the doctrine of res judicata is a part of Code of Civil Procedure. This doctrine is followed by courts to prevent the abuse of the process of law and to give finality to any proceeding or order and to avoid endless litigation to frustrate the very object of law. You see, it was held by National Company Law Appellate Tribunal in the case of Vikas Dahiya versus Aero Engineering Limited 2022 170 CLA 220 that doctrine of res judicata is applicable even to proceedings under the Insolvency and Bankruptcy Code 2016, that is IBC 2016. Hence, in any collateral or incidental proceedings, the judgment cannot be agitated which attained finality. If such course is permitted, it would amount to exercise of power of review of its own judgment or judgment which is not permissible under law.
Okay, sir. Moving further. Sir, my next question is relating to whether an application under Section 9 for default in payment of operational debt. Sir, could you please explain as to whether in an application can be admitted under Section 9 of IBC 2016 if there is a pre-existing dispute between parties?
Really, very good and interesting question.
Thank you.
As per section 952D of IBC 2016, if a notice of dispute has been received by operational creditor or there is a record of dispute in the information utility, then NCLT must reject the application under section 9 of IBC 2016. It was held by Honorable Supreme Court in the case of Raj Ratan Babulal Agarwal versus Solar Flex India Private Limited 2023 173 CLA 269 Supreme Court, that the court does not need to be satisfied that the defense of pre-existing dispute is likely to succeed. The court does not at this stage examine the merits of the dispute except to the extent that the dispute is not a patently feeble argument or assertion of fact unsupported by evidence, so long as a dispute really exists in fact and is not spurious, hypothetical, or illusory, the adjudicating authority has to reject the application.
Okay, sir. This brings us to our next question. Sir, I have a very complicated question to ask you.
Okay, ask. No problem. Let it be
Sir.
complicated.
Okay, sir. Thank you. Sir, whether a financial creditor can initiate insolvency resolution process against personal guarantor of a corporate debtor under section 9(5) of IBC 2016 after conclusion of insolvency resolution plan?
It is indeed a complicated question, as you say. But I must tell you that this issue, this complication, has been finally resolved by Honorable Supreme Court in the matter of Lalit Kumar Jain versus Union of India 2021-162 CLA 312 Supreme Court. It was held in this case that the resolution plan approved by adjudicating authority, that is NCLT, is not for recovery but it is for revival. As per section 134 of Indian Contract Act 1872, a guarantor is discharged of its liability towards his creditor only if the creditor on its own instance discharges the principal debtor through voluntary act of the creditor and not due to operation of law. Therefore, conclusion of resolution plan does not bar the financial creditor to initiate insolvency resolution process against the personal guarantor.
Okay, sir. Thank you for taking my complicated question so simply. Okay, now we come to our last segment, that is adjudication of penalties under section 454 of Companies Act 2013. Sir, please tell us any latest case where Registrar of Companies has adjudicated penalty.
Yes, I will certainly tell you. Under the said section 454, Registrar of Companies is authorized to act as adjudicating authority to adjudicate penalty in case of violation of certain section of Companies Act 2013. In the case of Maya Spinners Limited, Registrar of Companies, Madhya Pradesh, wide order 1st June 2023 imposed a penalty of 3 lakhs on company and rupees 1 lakh each on directors for violation of section 149(1) read with section 172 of Companies Act 2013 for not appointing woman director as required under the said section. So, thank you audience. We'll meet again. Bye.